Today's video has Vikings in it, so stick around for that. But a question I'm often asked and crops up in the comments is, what is the difference between unlawful and illegal? Well, I can cut to the chase and say, as far as the law's concerned, there is no difference. But how do we arrive at that? Well, let's look at the dictionary. I'm using Merriam-Webster because it was free. So what does Merriam-Webster say about unlawful? It says, see illegal. Oh, okay, so what does it say about illegal? It says, see unlawful. So that's a bit circular, isn't it? But it's just a dictionary. Now, we do sometimes use regular dictionaries in court. When judges are trying to decide what is the meaning of an everyday, ordinary English word, as opposed to a technical legal term, they will start with the dictionary. So they'll say, you know, what's the definition of motor vehicle? Well, what's the dictionary definition? But then, of course, you get all these modifications in things like all this sort of road traffic acts and all the regulations. I saw an interesting example of that once when I was waiting for one of my cases to get on. There was a young lad up, and the night before, he'd been out on the lash in London, and he'd grabbed one of those street sweeping machines, the ones where you sort of steer them with motorcycle handles. He turned the throttle, he made it 3 feet, and he just crashed it into a bollard and broke one of the headlamps. Problem for him is, as a matter of law, they are road vehicles, those things. So he was done for aggravated taking without consent and drink driving, much to his shock and horror. But what about legal dictionaries? We do have them. We have specialist legal dictionaries. There's one you get seen a lot, which is Black's Law Dictionary. But that's actually an American one. The current editor is a guy who's written lots of books, including quite an interesting book about golf. And you know, while Black's has been going for donkey's years, it has numerous editors. But that only applies, that you know, like I say, that just refers to American law. We do have some English ones. But the thing to understand is, these are just designed to help law students in the early stages of their career. So they will list legal terminology. And they'll give a bit of background to it, they'll say what it means, and they might cite a few relevant cases and bits of legislation. But these things are never used actually in court, because the only things we cite in court are either primary or secondary legislation, or case law, you know, authorities from decided cases, because that's, you know, how a common law country works. So most people, they will buy a law dictionary when they start their legal career and then never look at it again after the first couple of weeks. So let's look at some examples from you know, the actual law itself. But the thing to remember is, as Terry Pratchett said, English doesn't just borrow from other languages, it takes them down dark alleyways, tips them upside down and rifles through their pockets. And although, you know, England's been around a very long time, it's got, you know, quite a mixed history. So it's mainly the fact that it's the merging of two legal traditions, one that used Norman French and one that used Norse. I mean, Norman French features a lot in the law. You go into any courtroom and you'll see a big symbol behind the judge with the slogan, "Honi sont les mal et passe," shame on he who thinks this evil. The funny thing is, that actually started out as a smutty innuendo. Ladies used to write it on the top of their garter. Their stocking, the garters on their stockings. So the idea is, if you caught a glimpse of that and were thinking illicit thoughts, it was like, oi, stop it, matey boy. And for some reason, because we had the order of the garter, which again, you know, you look into this, it is literally just, that all started with somebody presenting a lady's garter to somebody. So I always find that quite interesting, it's in there. But like I say, so Norman French features a lot, but as I will come on to momentarily, so does Norse. But let's look at some cases, some legislation. The Offences Against the Persons Act, that makes it an offence to set a spring trap. But you'll notice there are 2 exceptions to that, whether you're catching animals or whether you're dealing with trespassers. And what it says there is, although it's generally unlawful to set such traps, or it's illegal to set such traps, it says it's not unlawful or illegal in these situations. But what's interesting there is, even though it gives the 2 exceptions, in one exception it uses the word unlawful, and in the other exception it uses the word illegal. So, you know, is there any difference there? No, it's meaning the same thing. It's just saying this is a defence to a crime. You know, we use unlawful a lot in criminal law, you know, unlawful wounding, you know, GBH and things like that. I mean, some people suggest that unlawful is more of a civil thing and illegal is more of a criminal thing. But it isn't. Like I say, we use unlawful in criminal law all the time. But do we ever use illegal in civil law? Yes, we do. And there's a really interesting case on that. It's actually a very technical, boring property thing about whether you can breach leases and things like that. But it's all to do with whether you are acting unlawfully or illegally. And what's interesting is it says it is illegal. If you do something illegal, then these particular provisions arise. But if you read through it, and I'll leave it up there so you can read it yourself, it actually goes in and distinguishes between, does it have to be illegal in the criminal sense or merely illegal in the tortious sense, tort being civil law. So again they're accepting that the two words are completely interchangeable. So you can use, we do say that in contract law, we'll say sometimes this contract is void for illegality. And that doesn't necessarily mean that it's a contract to commit a criminal offence. It might just mean that as a matter of civil law, there's a provision in there that cannot stand. So there you go, yeah. I'll be very interested to see your comments, and I suspect there'll be quite a lot of people disagreeing, but all I'll say is look at the legislation and look at the case law. But anyway, Vikings, because this is all very relevant. After the Norman conquest, William the Conqueror inherited a country that was quite fragmented. And don't forget, at the time, there was a huge Viking influence there. He'd literally, poor old Harold had to fight off various Viking people and then come back and lose at Hastings. And interestingly, the Normans were themselves Vikings. Norman just means it's a abbreviation for Norsemen, because they had been given part of France as a sort of a settlement deal for please don't murder us. If we'll give you this bit of land in lieu. But he wanted to unify the country because it was very fragmented and it had lots of different legal systems. So he sent out a commission called the General Eyre, E-Y-R-E. And the idea is that they would go around, examine the law in all the different areas. It's a bit like the Doomsday Book, where he was just going, right, what have I actually inherited here? What have I just won in terms of this country? So they looked at all the different sort of like legal systems in different parts of the country. And the idea is he wanted a sort of best practice. He wanted to unify the country by imposing a common law that would apply everywhere. But when the commission arrived in what we call the Danelaw, which was the part of the country that was still very Viking influenced, they said, well, look, we can see actually the benefit of having a bit of a general common law, so everybody knows where they stand and you don't have like people running like the Dukes of Hazzard from one part of the country to the other because what they did there isn't illegal in a different part of the country and things like that. They said, okay, we can see why there is some a reasonable interest in having a common law, but we like having a lot of our own local laws because we know best. So they said, we actually have a rule where different individual towns and cities and settlements have their own laws. Now, interestingly, the Norse word for a settlement is by, as in all the names like Grimsby and Wetherby and Hornsby and all that sort of thing. And their word for law is obviously law. So they had their local laws, which they called bylaws. And that's where we get the term bylaw from. And that's why individual like towns and cities and local councils can actually, for some things, set their own laws. It's like, it's not, the speed limit does not apply to pedal cyclists. However, local authorities can in fact impose speed limits on cyclists by introducing bylaws. So, they're still very relevant today, but like I say, that's a use of two Norman words there. So there you go. As always, I hope you found that vaguely interesting, vaguely useful, vaguely accurate, and I would be very interested in your thoughts on this. But there you go. When somebody's saying what's the difference between unlawful and illegal, as far as the law is concerned, there just isn't one. So there you go. Apparently some of my grammar friends have said sometimes you will use one or the other because they scan better and work in English, and one sounds a bit clumsy and one sounds a bit better. But that doesn't have anything to do with their actual legal effect. And also, because of a bit of rare winter sunshine, I thought I'd dig the old shirt out and the sun hats, because I know you like to see this shirt, and also it's just so nice to have an excuse to actually wear my sun hat as opposed to my rain hat or woolly hat. It's not real wool, obviously, because I'm a vegan.